Okay, well, I'm starting now. Okay, everyone, thank you. My name is Makenna Hoffard. I'm an associate attorney here at Beresford booth, and I'm going to talk today about adult guardianships and less restrictive alternatives. Um, the concept of guardianship is kind of the first thing that we need to cover then. What is a guardianship or conservatorship? The definition I've written in here covers, it's sort of my condensed definition for an adult guardianship. But just kind of to start things off, I usually tell clients, you're familiar with the idea of a guardianship and conservatorship. You're just not used to that language. So a guardianship or conservatorship we see all the time because we see parents all the time. Children are always under a guardianship or conservatorship because they're not deemed to be capable of signing contracts, getting married, driving, owning property, all of those things, right? Voting until they become an adult, because they're viewed as not having capacity to understand the weight of the decisions they're making. So for adults, guardianship and conservatorship is the same concept, but just you're moving backwards like you're Benjamin buttoning. So my definition for a guardianship or conservatorship is a legal process where a court appoints a decision maker for someone who is incapable of exercising their rights or providing for their basic needs on their own. So typically, the legal process consists of filing a petition explaining why that adult, called the respondent, needs a guardian or conservator. Then the court will appoint a court visitor who's a neutral third party who goes to investigate what's going on. They go visit the respondent, talk with them, talk with family members, see their house, examine medical records, examine bank records, anything that might be germane to the case. Then the court will hold a hearing that reviews the petition, the court visitor report, any other materials that get filed within the case, and then either appoint a court visitor or deny the petition and say that no guardian's necessary. So some of the things to keep in mind here, it's a long process, and reasons to avoid it is because the respondent, the adult who is being placed under a guardianship or conservatorship, loses legal rights. They become as if they were a child almost in some ways, where they lose the ability to vote. They could lose the ability to drive. They lose the ability to marry or divorce without their guardian's consent, to enter contracts, to sue or be sued except through their guardian, etc. So not exactly the most fun process. So here's my basic divide too. So guardian, that is someone that's appointed for taking care of the health, safety, and welfare of the respondent. And a conservator is in charge of property and financial decisions. So we might see instances where there's an adult who needs a guardian, but they don't have any money. They've spent it all down. They don't have income. They've got a rep payee for their social security income, and that's the only thing available. They don't need a conservator because there isn't an estate to manage or take care of. There's no property in question. It's just they need somebody who's making decisions for them, on the medical side, on the social side, and just ensuring their safety and that they're taken care of. Yeah, and the language did change recently under the Uniform Guardian Act, which was enacted in Washington the January 1st, 2022. So we've had a year with it. It used to be called guardian of the person and guardian of the estate. So now the terms are guardian, conservator, conservator's money, guardian's medical. Situations where an adult might need a guardian, the most common ones that we see are a child that has a disability that's always needed their parents' help, turns 18, and they still need help. They still need someone who can communicate on their behalf, make medical decisions for them, take them to and from doctor's appointments, get them signed up for classes, XYZ, right? And so they go from mom and dad, you're in charge, you are the guardian, to all of a sudden their guardianship rights terminate when the child turns 18. And so they need to go through this process to get appointed to continue caring for their child the way they have been. Other instances we see are that someone gets in an accident that results in disability or incapacity. So car crashes, strokes, something that would cause someone to lose the ability to speak for themselves or to understand what's going around them, so they can't actually comprehend the weight of the decision they're making. And then the other one that's incredibly common is an elderly adult becoming older and developing dementia or some other form of memory problems where they really just don't understand what's going on, can't comprehend, again, the weight of the decision they're making or what the long-term effects will be, can just be talked into anything or very susceptible to abuse at that stage. And then, yeah, just in general, there's a lot of different options that could cause someone to need a guardianship or be a candidate for it. Those are kind of the three I see most commonly, though. So what are some alternatives to guardianship now that we've established that it is bad and you don't want it? So the good news is the court prefers less restrictive alternatives. They do not like to take away an adult's legal rights. It's not something they're keen to do. They want you to find something else that will still protect and provide for the adult, but won't necessitate the removal of those legal rights. So the alternatives that are most common are durable powers of attorney. This is, I think, the best option. It helps you maintain all your rights. It's the one where you pick your decision maker. We'll talk about it more in a minute. There's also supported decision making. This is a great option for having somebody get some help without losing any of their own authority in their life. And then the final one that is as close as you can get to a guardianship without being one would be a protective arrangement of some sort. So we're going to kind of work backwards on that list, and we'll start with protective arrangements. Oh, no, I take it back. We're starting with durable power of attorney. So durable power of attorney is a document where a legally competent adult, who we call the principal, nominates somebody to serve as their attorney-in-fact or agent to be their decision maker for medical and financial decisions if that principal is unable to communicate or make the decision for themselves. So instances where we really recommend everybody have a durable power of attorney. I can't think of a single reason you shouldn't have one in place. But the way it can be set up is that it's effective immediately, meaning that when you sign that durable power of attorney, your trusted individual can go ahead and make decisions for you, or it can take effect only when you're not able to communicate for yourself. Either way, this is an incredibly helpful document for avoiding guardianship and conservatorships, because when you hit a point where you can't communicate yourself, you can't make decisions, or you just don't understand the weight of the decision being made, then you already have somebody named, right? You've chosen your attorney-in-fact or agent, and you can just avoid a guardianship altogether almost every time. The one instance really where it doesn't work is instances of abuse, where maybe you name someone that was trusted and then they've started using your money for themselves and not for your care. That's the one time I've really seen it work around. But it's really the best option because you're choosing who you want in charge of you when you're not able to take care of yourself anymore. And typically as well, if it's a well-drafted durable power of attorney, it will name who you want as your preferred guardian, so that if a guardianship is ever filed, you have a document that says who you want to serve and be in charge of you if that's necessary. So it really helps you maintain control of your own life, even in the event that there's an emergency or just mental decline in old age. So the next one I want to talk about is supported decision making. Now, this is kind of a newer one. I haven't seen it used a lot, but I think it would be a very helpful document in a couple different scenarios. So a supported decision-making agreement is a document where a legally competent adult with a disability, which the statute defines as a physical or mental impairment that substantially limits one or more major life activities, nominates a trusted individual as their supporter to assist them with understanding the options, responsibilities, and consequences of a decision, collecting, accessing, and obtaining information, think medical, financial, educational, etc., and then communicating their decisions to appropriate persons. So this one is different from the durable power of attorney because it's not someone making a decision for you. It's not taking you out of the equation, but it's acknowledging that there's something that would stop you from being able to effectively communicate. And you have somebody who can come in and help you with that, but they are barred from actually making any decision for you. They can only assist you with it. So instances where I think this would be really helpful, the main example I came up with here is one of my nephews is deaf. And so this is a document I've got in mind for when he turns 18, that he may want to nominate a parent or sibling or friend to be in charge of helping him with calling the doctor's office and getting his medical records so he doesn't have to jump through loopholes. I know there's more accessibility stuff, but that is definitely one that can be harder. It can be time consuming. It's not as easy, or the world is just not set up for him. Picking up a phone and calling someone is a lot easier than needing to do a Zoom call to ask them to wait for an interpreter, to make written requests of everything when they need to authenticate, etc. And so it might be better for him to just have somebody named who can call to help access information and then communicate what he decided to an appropriate person. So that's something to kind of keep in mind, I guess. There's a lot of different scenarios where that would work. This is really geared toward people with limited communication ability, where you have a caretaker, family member, friend who can understand you and you communicate well with them and you are perfectly capable of making decisions for yourself. But there's some issue with communicating with the rest of the world, right? Someone else might have a little more trouble understanding you, or you're just don't want to, quite honestly. If you have something where you go, this is limiting my ability to be mobile and I'm required to go to the bank in person, I want to set this up so that, my friend can go down to the bank for me, get the information, bring it back to me. I'll make my decision. They'll take my decision back to the bank, XYZ. So again, it's not something I've seen used a lot because it's not really an emergency document. It's just making your life more functional by adding in someone who has limited legal authority to assist you and access your documents. It does not help, though, in the instance of an emergency. And this is where a DPOA is definitely something you still need, even if you have this, because if there's something where you lose all ability to communicate, if an emergency situation arises, your supporter is not a decision maker in any sense of the word. So you would still need both. But it's kind of a useful distance where you don't lose legal rights because you have somebody helping you make decisions, and you still get to make decisions for yourself. So then the last option here that we'd run into is protective arrangements. So a protective arrangement usually results from a guardianship or conservatorship legal proceeding. It follows the same process. Someone petitions the court, it goes through court visitor, etc. But instead of asking that the court appoint a decision maker for an indefinite period of time, right, where they just are always the guardian, they're always the conservator until they get removed, then the petitioner would instead just ask that the court authorize or restrict something. So some examples I pulled from the statute are that the court could authorize that the petitioner can apply for benefits on behalf of the respondent if they need state aid. You know, I see this a bit with Medicaid of, I need to get this person on Medicaid, but you know, they're recovering. I don't think they're going to need a long-term guardian. I just need to get them on it. That can be a useful process to just petition the court for an order specifying just that. To sign a contract on their behalf. Again, I usually see this in the context of getting somebody into a care home. And so you just need the authority to sign that contract on their behalf to get them set up. And then the other option would be to order for someone's access to the respondent or the respondent's stuff to be restricted. Typically, we see that in instances of abuse occurring, right? Someone's going in and causing problems, and you just need authority to tell them they have to stay away. And for whatever reason, the respondent is not telling their caretaker, care facility, whatever, or they're incapable of telling the person that you have to leave me alone, or they don't understand that that's not an okay relationship for them. So that's where you might need to get the court involved. But again, you don't want to set up a full guardianship. You just don't want them to be around this one person who's harming them. I haven't really seen that one as much, because typically if the respondent is at a point where they don't understand that someone is harming them, they're very much at risk of it happening again and again. So usually if you're at that point, you're probably going to need a guardianship, which is why protective arrangements really aren't, they're not as great an option, because you end up coming back to court again and again and again. So yeah, like my notes say here, it's a one-time solution for some problems, but it doesn't give you permanent authority. It doesn't really remove a respondent's rights, except for to that one decision. But it's really not a consistent long-term solution. So it's less work for the petitioner in the long run, because you're not a guardian, and guardians have to file annual, biannual, or triannual, whatever the court orders, reports where they say, here's what happened, here's what's going on with the respondent, here's what our year to 3 years held. So it is a guardianship is a big job. It's not something that goes away, and you are accountable to the court throughout the whole process. So protective arrangements necessitate a lot less from the petitioner, but in my experience, they usually end up being more expensive in the long run, because you have to keep coming back to court because new problems keep arising and you don't have authority to deal with them as they crop up. You have to go back to court every single time. So that's the process. Those are the different options available for avoiding guardianship, things to think about. If you have any questions, please let me know. Here's my email and phone number, and I look forward to hearing from you. Thank you.